Right, so hello everyone, it's Jeff Gilmore from the Association of Residential Communities, ARC as it is commonly known. Thanks for downloading this YouTube video where we are exploring and holding discussions with a range of business partners on all aspects of estate leadership, estate management, and various other solutions that many of our business partners are providing. So today, it's really a critical discussion, an important discussion, one which we sometimes don't look at in too much detail or in as much detail as we should. We find ourselves, Lozelle, that we are caught in this dilemma of everything is focused around COVID, and sometimes we forget the other important things, specifically from a legal aspect. So we're going to be talking about some of the issues around governance, rules, regulations, MORs, constitutions, and the important aspect of annual general meetings during these times of lockdown. So we're joined by Lozelle Parla from Cox Yeats, and it's fantastic to have you with us today, Lozelle, and thanks so much for joining us.
Pleasure to be here.
All right, excellent. So let's kick right off. Governance is really, really important. But why is it so important for a homeowners association and our environment that we find ourselves in to make sure our governing documents are aligned to the Companies Act? Is that important, and then why is it important?
Well, Jeff, obviously, if your homeowners association is a company, a non-profit company, then it is subject to the Companies Act. That act was amended, as we know. We moved from the old Companies Act to our new Companies Act of 2008, which introduced some changes to how companies were set up and the regulatory requirements for them and procedural requirements. And you may well find that you have a document that hasn't kept pace with time, hasn't kept pace with how the law has been interpreted. You want to be able to sleep peacefully knowing that your document is not open to challenge and that it has kept abreast with the current law. So whilst you may have had a perfect set of documents that when your estate was set up, they may have fallen behind the times. They may also no longer suit your needs entirely. That's why it's important to conduct a fairly regular review of the documents. If, of course, you're not a non-profit company and you set up as a voluntary association, you would have a constitution, and similar considerations would apply. Although you don't necessarily have to keep up with the Companies Act, it's important that you've had assessed your documents and you know that they actually are clear, unambiguous, and lawful. I've seen many constitution and rules that just don't hang together properly. Same goes for MORs and rules of non-profit company homeowners associations, where although the one document is perfect, it doesn't necessarily talk to the other document, because as often happens, there might have been different authors to the documents. They may have been produced at different times without reference to each other. And you might find that you're sitting with a set of rules that don't necessarily talk to your MOR or constitution, because bearing in mind, that is what gives life to you. That's what circumscribes your powers. So it's pointless having an extensive set of conduct rules if you're sitting in a homeowners association that has, for example, a constitutional homeowners association, which very narrowly defines the objects of the association. You may find that you've actually overreached, you've extended your powers in trying to enforce those conduct rules. So it's really important. It's important to give the directors or trustees peace of mind that what they're doing is lawful, and also for homeowners to know that there's no overstepping of boundaries and that what they're being required to do and comply with is competence.
So in a company or a non-profit company, where that particular community or homeowners association have the act to guide them in respect of what they include or exclude from their MOI, in a common law association, they wouldn't have that. And very often we find that many communities say, well, we don't have to comply with the Act, therefore we can write anything into our constitution. That's not true, is it?
It must still be lawful. It must be constitutional above all, in accordance with the overriding constitution of the Republic. And it must be a clear, as I say, clear and unambiguous document. You may not necessarily have to comply with the provisions in the Companies Act or, for example, the Sectional Titles Act, but it's still a contract between you and your members, and the normal considerations would apply. It's pointless having a document that's so unambiguous, so unclear, so draconian, and potentially not respecting of persons' constitutional rights, that you having it set aside. So yes, you might not have to comply with specific legal requirements, but you need to comply with that document itself, and you need to know what it in fact says and prescribes to you.
So we often see a situation where a board of directors is elected, especially when there was this need to change our Articles of Association into an MOR. And many communities made the mistake of going onto the government website and downloading a template of an MOR and simply going through that template and cutting and pasting from that template to make sure that they only applied to the Companies Act. There's so much more that one should consider when developing your MOR.
Yes, you don't want a vanilla MOR. It's not going to serve your purposes necessarily in a homeowners association. So going and getting something off the shelf is really not going to cut it. You need to tailor make it for your community. You need to provide for your ability to create conduct rules, not just company rules, but rules of conduct that will govern members on a day-to-day basis. You may want to entrench certain provisions in your document that make it harder to change, and that's why you'll see many provisions in an MOR, or for that reason a constitution, that goes beyond what the drafters of the Companies Act legislation would have had in mind. It will deal with things like amenities, maintenance of units, selling of and alienation of units or land. It will deal with the power to create rules of conduct, and so on and so forth. And also, of course, membership and the rights of it, which will not necessarily be the same from one entity to the next. So that's where it's very dangerous to go and pull a precedent or copy from your neighbor. And you know my attitude about that, Jeff.
Yes.
It's very hard to standardize. Whilst you may be able to have some framework, it's nothing more than that. You might be able to look and compare with constitutions or MORs of other entities. But unless you're familiar with where your association or your community is coming from in terms of its own development approvals and obligations that might be there, you can't just go and take these provisions and apply them verbatim to your association. I've seen many, and I've advised in many instances where one has sat with articles of association and you've been in a process of converting to an MOR, and you get told, oh, just take that one out and take this one out, provision out. And it's very dangerous, because if you know, in those instances, we've been able to point to the original development approval and be able to show that this was actually a condition imposed by the municipality when your development was approved. You can't now just go and lose it for all eternity by removing it from the document. You have a binding contractual relationship or binding obligation in terms of your development approval that you need to carry forward. Likewise, conditions that might be in sale agreements that you can't just lose. So it's so important to have an overall understanding of your particular environment and what has informed the establishment of your association and the right and obligation of members to be able to tailor make the document. Otherwise, a lot is going to get lost in the wash.
And I suspect that the same would apply to any other of your governing documents, like your rules and regulations. I mean, you've got many workshops in our industry, and you consult to many estates in our industry. And I would have it as a guess that that the question you get posed many times when we're discussing, I remember in our last workshop, or was it our last chapter meeting, where you were speaking about rules and regulations, and the first question that comes up was, Ach, Lizelle, design us a nice little template with all the standard rules and all the standard regulations so that we can use it as a template and then just cut and paste it to make it look nice. So it's not only about our MOI that we should adopt that principle for, it's also the rules. And our rules must talk to the MOI. You know, they contradict each other very often.
You may very well have fairly standard provisions dealing with roads. You may have standard provisions dealing with the upkeep and maintenance of a unit that you can put in. But the whole bundle, the whole document itself can't simply be borrowed from your neighbor necessarily, because it may not apply. You may go and take the rules that apply in a golf estate and try and apply it in an equestrian estate. They have completely different considerations. So whilst there's parts that you can adopt, the whole document may end up looking different. And it's very important not to get trapped into that what might seem easier, just borrowing from someone else. But then when you read the entire document, and you'll know as well as I do, Jeff, you sit with the set of an MOI and a set of rules, or a constitution and a set of rules, very easy to pick up when someone's just gone and borrowed from one document and plugged something in, and you then read the rules and you realize there was a completely different author who created that document without any reference to the overriding MOI or constitution. They should very much be done in tandem. And that's why I find it not to be the most useful exercise to simply do a high-level review of an MOI or constitution without actually having looked at the other governance documents, because you can throw things out of kilter. And, you know, a slip of a word can cost you, because suddenly you change a definition in the one document. We find very often the conduct rules often don't even have a definition section. They're relying on definitions in the MOI or constitution. Something as simple as dropping a definition in the one document might have a knock-on impact in the other. It's a simple and absurd example, but it's so important to do them together, because those are your primary documents. And then of course you have your whole host of protocols, policies, guidelines that will sit either alongside or underneath those documents, and also needs to be consistent. So, you know, what may be applicable in one estate in terms of the control of buildings and conduct of architectural controls may be completely different on another estate. So if you've gone and borrowed it from one without reference to those underlying obligations, you are running a risk.
And you know how often I've seen such poor cut and paste jobs, where even as an example, if you do too much of that, because generally they'll end up to be fairly long documents, that when you cut and paste, you still retain the fact that they make mention of an association that's not even your association. I mean, it's ridiculous, you know. And
I've seen where the intention was, for example, to create a voluntary association, and then throughout the documents you're seeing references to the Companies Act
or Sectional Titles Act.
Yeah. That are just totally not applicable in those circumstances. And the difficulty comes when it lands on your desk as a dispute, and you now have to try and find justification or interpret what is actually going on, because more often than not as well, there's governance that takes place without reference even to the documents. So the horse bolts. You've got these nice documents, but on a day-to-day basis, no one pays attention to them. They conduct affairs assuming what would be the law, assuming, well, okay, in a sectional title scheme, I can do this, that, and the other, or in a company, I can do this, that, and the other because of my experience in running a business, but haven't actually looked at the homeowners association's governances in that particular instance, which may fly totally in the face of what you used to doing in another scenario. Yes. And that becomes very risky and dangerous. You need to have reference. That is your Bible on a day-to-day basis, which informs what you can and cannot do. Don't make the mistake and fall into the trap of thinking, oh, well, I know this. I've been in a body corporate before. and I know how we can have our meetings and calculate our votes and deal with our proxies, and you don't go and look at your own particular documents. Bearing in mind as well, if you're a non-profit company, in your setup, the Companies Act provides for the alterable and non-alterable provisions.
That's right.
It can be altered. You may decide in your association that you want to change a particular provision, whereas your neighbor may decide that they don't. They don't want to change it, and that's where it becomes dangerous to make the assumptions without reference to the document itself. And also it becomes difficult to amend documents because there's a whole host of options you have as the driver of these documents where you need your board or your association to apply its mind as it wants to conduct its affairs in that particular instance. So quorum requirements, meeting requirements, and the like.
And the reality of the situation is that you probably will never, when you design all these important documents, you don't understand that it is when someone challenges it and it lands up in front of a judge or a magistrate, and all of a sudden you are now in a pickle, and the cost of that is enormous. So much more than the cost of just getting good legal advice. So, talk a little bit about the need for homeowners associations to make sure that before they finalize all of these documents, that they've obtained the correct legal advice.
Well, Jeff, as I've said, you attract potential liability, and you also have the risk of having decisions and actions set aside in a court of law with potential hefty cost consequences. So it is important to be up to date. Obviously, as a member of ARC, you keep your members up to date, but sometimes I see even in the industry a knee-jerk reaction. A decision gets posted on the website and everyone thinks, okay, quickly we need to change something based on what they believe to be the import of the decision, and it may not necessarily require a change in their particular instance. Yes. So yeah, it is important at whatever level to try and get some input. Very often homeowners associations are ably resourced with attorneys or people with legal knowledge or business knowledge sitting on their boards that can guide these changes. But you do sleep peacefully at night, I think, if you've actually had it reviewed and you know that you're keeping pace with what the law requires.
Okay, that's fantastic, and that's such good advice. So finally, I've got one last question to ask you. We're in COVID lockdown at the moment. AGMs it's at this time of the year that many AGMs are being held. We've got communities that have scheduled these already. We've got communities that have in fact set the dates and sent out their notices already. We've got communities who are grappling with the fact that their MOI requires them to run the AGM within a certain time of the end of the financial year, as an example, or the end of the last AGM, depends on what is contained in their MOI. Talk to us about the holding of AGMs and other member meetings at this time.
Okay, well, here we need to distinguish between a non-profit company and your voluntary associations, which would be your homeowners associations that are governed by constitutions. In relation to those that are non-profit companies, we turn to Section 63(2) of the Companies Act, which reads as follows: unless prohibited by its memorandum of incorporation, a company may provide for a shareholders meeting to be conducted entirely by electronic communication, or one or more shareholders or proxies for shareholders to participate by electronic communication in all or part of a shareholders meeting that is being held in person. And now here's what's important. As long as the electronic communication employed ordinarily enables all persons participating in that meeting to communicate concurrently with each other without an intermediary and to participate reasonably effectively in the meeting. So your first inquiry is check your MOI. Does it prohibit electronic communication and meetings to be held electronically? If it does, you have no alternative but to postpone the meeting. And you would be excused by a principle in our law, which is called supervening impossibility of performance. You are prohibited in terms of national legislation and requirements from actually having this gathering of people. So you have no choice but to postpone it, and that is in line with the most recent CSOS directive, which confirms that associations will not be penalized for having their meetings at a later date, although that directive does refer to the fact that the associations may have it a virtual meeting, but obviously it doesn't take into account that you simply cannot do it if you have an MOI that says you cannot have electronic communication or participation in meetings. So that's number one, your first inquiry. Then if your MOI is silent or actually says that you can do that, then you need to provide for it to be held electronically, provided, of course, that you can comply with that requirement that says that the electronic communication employed ordinarily must enable all persons participating in the meeting to communicate concurrently with each other and to participate reasonably effectively in the meeting. So you would need to make sure that you have the appropriate IT systems in place and that everyone can participate reasonably effectively. So my advice is to go out to your members to first ascertain to what extent they are able to participate in such a meeting were you to commission the setup of the necessary IT systems, because it doesn't help if you're in an aging community that doesn't necessarily have access to tablets, to cell phones, to computers. It may actually not be an effective mode of having your meeting. So just at a very practical level, determine that. And secondly, make sure that you can commission a system that actually does comply with the Act and enables you to issue the notices, to accept the proxies, to conduct that meeting electronically, and to actually be able to determine and conduct voting on that electronic platform.
That's true.
If you've got that in place, you also precluded from having that meeting. But I think you would need to be able to exhibit the fact that you've gone through these steps, that you have actually made some attempt to comply with the provisions of your MOI, that you've tried to provide for the meeting to be held electronically, and perhaps you either can or can't. That's going to be a question of fact. And it may well be more difficult in an association with an excess of 1,000 members than for an association that maybe has 10 members. Yeah. So there's different considerations from one community to the next. Okay. Obviously, in relation to an association that's a voluntary association, you look to your constitution, which is the contract between you and your members, to determine whether it is prohibited or whether it may be permitted. Maybe a bit trickier where it's silent, then I think you would fall back on the CSOS directive, which actually indicates that you could do it in that manner. And you'd soon see if there's going to be an outpouring of objection where people insist that you shouldn't be having it in that mode. You also need a system, and this requirement in terms of the Companies Act would be a logical requirement almost to import in those circumstances, because a system that does allow people to participate reasonably effectively and to communicate concurrently, then I believe in a voluntary association you would be at risk of having your meeting set aside if you, for example, commissioned a system that didn't allow people to participate reasonably effectively. Maybe it's a system that only allows 10 people on at a time and you need to have 30 people on at a time. Another absurd example, but you may run the risk of having an invalid meeting, one that's subject to being set aside. So once again, consider your actual documents, consider the needs and the abilities of your community and your association to host a meeting in this fashion, and communicate at all times. Communicate your difficulty to your members. You are there for your members. You're an extension of them. So let them know what the documents provide for. Let them know what difficulties and challenges that you are facing, and get them on side. So it's not a them and an us situation where you appear to be maybe frustrating members' needs to have meetings. I'm also alive to the fact that at these times, a lot of boards are coming under attack from their homeowners for potentially doing or taking steps that are not necessarily popular, but may be compliant with the law. And members want to have a forum to air their views. So they're keen to participate in a meeting to put these issues out there, and the meeting's not happening. So rather go out to the members, explain what your challenges are, and make every attempt to try where you can have an electronic or virtual meeting to set one up. But make sure that it's going to be a meeting that once it's held and once votes are counted, are going to be legally unassailable. So you need to have the confidence in that system and the ability for that meeting to be properly held in accordance with whatever your particular documents require, and in accordance with the Act where the Companies Act applies.
And what I hear you saying, that even if you're a constitution with a common law association and you don't have to comply with the Act, it could be deemed as best practice to at least use what resources you have available that would give guidelines to fairness and equity and consultation.
Yes, Jeff, it makes absolute common sense. And if you haven't got a system that's going to allow people to participate in the meeting reasonably effectively, then you're not having an effective meeting. You might as well postpone the meeting and have it at a time that you can. But, whether it's your AGM or just regular meetings, most associations are going to have to cross this bridge at some time. You may be able to put it off for so long, but we don't know how long these restrictions are going to be in place, and there may well need to be decisions made. Doesn't preclude, obviously, where you can have decisions taken by way of a round robin, where you need an urgent decision, for example, on expenditure, but even that becomes difficult and challenging in these times.
Always fascinating to talk to you. Every time I talk to you, I learn something new. And I hope that everyone watching will get value out of this discussion that I've had with Lizelle Parler from Cox Yeats. So Lizelle, it's been fantastic having you. Once again, I know we are scheduling some workshops where we're going to do it in a webinar format. We'll be looking at that, you and I, and then determining a cost for people to then log on to the webinar, where we can explore, as an example, you wanted to unpack, or it came from one of our members, the desire to have you to unpack some of the CSOS decisions that were taken and the ramifications of that. So watch out for those adverts. Once again, it's been fantastic having you, and thanks for your articulate and professional way of presenting, which is sometimes a tricky topic. Thank you, Lizelle.
Thanks, Jeff. Thank you.